Welcome to a live Zoom edition of the Ralph Nader Radio Hour. My name is Steve Scrovan, along with my co-host David Feldman. Hey, David, how's the house?
It's exciting. We're meeting our listeners.
That's right. David and I are two comedians, and that's what you always ask backstage before the show. How's the house? But I usually for us is, they look a little drunk, but not today.
Or in my case, empty. It's usually empty for me.
Yes.
Either in their heads or the...
Okay.
And we have, I also want to welcome our associate producer, Hannah Feldman, who's going to be moderating our live audience questions. Hello, Hannah.
Hello, Steve.
And of course, the man of the hour, Ralph Nader. Hello, Ralph.
Hello, the viewers, listeners. It's all about the headlines of today, bringing Trump to justice. All in the headlines. We're going to discuss it with the leading constitutional lawyer who knows what he's talking about, Bruce Fein.
That's right. Today, we were scheduled to hear lawyer Josh Koskoff. That's what we were promoting all week. He's the attorney who won a $73 million judgment against Remington and other arms manufacturers on behalf of the families of 9 victims of the mass shooting that took place at Sandy Hook Elementary School in Connecticut. Unfortunately for us, he was called away at the last minute to attend a congressional hearing in Washington, D.C. on the topic. Unfortunate in the short term for us, but potentially fortunate in the long term for the cause of sensible gun control. So we will reschedule Mr. Koskoff in the coming weeks and get an insider's view of how that hearing went and how Mr. Koskoff successfully argued his case in court. So stay tuned for that. But we are nothing if not nimble here at the Ralph Nader Radio Hour. So we've quickly switched gears. As Ralph mentioned, today we're going to talk about the recent news that the Department of Justice is investigating Donald Trump's role in the January 6th insurrection. According to the Washington Post, they are interviewing close associates of then VP Mike Pence, and I assume many others, as the days and weeks go by. Many have been clamoring for the DOJ to take action in light of what we've been learning through the January 6th hearings, and now it looks like it's happening. And to help us sort all that out, we have invited our resident constitutional scholar, Bruce Fein, to join us today. Ralph and Bruce will talk up front about the implication of the DOJ investigation. And then those of you in the Zoom room will have a chance to ask Ralph and Mr. Fein questions. It's going to be a relatively freewheeling conversation. I'm sure we'll venture into many different related areas. I know Ralph also has a complaint about a change in philosophy of the New York Times editorial page. So we'll see where this all goes. And as always, somewhere along the line, we'll check in with our corporate crime reporter, Russell Monkiber. But first, David, introduce our guests to the people.
Bruce Fein is a constitutional scholar who was Associate Deputy Attorney General under President Ronald Reagan. He has been a visiting fellow for constitutional studies at the Heritage Foundation and an adjunct scholar at American Enterprise Institute. He is author of Constitutional Peril, The Life and Death Struggle for Our Constitution and Democracy, and his other book is American Empire Before the Fall. Welcome back to the Ralph Nader Radio Hour, Bruce Fein.
Oh, thanks for inviting me.
Welcome back, Bruce. We're going to cover a lot of ground, and it entails all the questions that a lot of people are asking that they're not getting answers to from the January 6th committee and from the Justice Department. All over the front pages today, Washington Post, New York Times, they've reported that for some weeks now, there's been a grand jury impaneled by the Justice Department to investigate the insurrection and the predicates leading to the mob against the Congress on January 6th to obstruct the certification of the election in favor of Joe Biden. Let's start with this section, Bruce. The committee has a lot of staff. They've gotten a number of hearings with pretty good ratings. They seem to have been doing a good job, but they're not using the priority powers that they have with Trump, Pence, and other arenas that they can open up and strengthen their case. You've made a list of these. Can you go through them one at a time? And then we'll talk about how the January 6th investigation is taking attention away from the serial daily statutory crimes and constitutional violations of Donald Trump in his 4 years in office.
Yeah. Well, thank you, Ralph. Well, the first thing is we need to remember that one of the refrains of the committee has been the dereliction of duty of President Trump, during these 187 minutes of insurrection, where he sat and fiddled while the Constitution was torched. But there's been a dereliction on the committee side, too, and let me explain. They have unchecked inherent power to subpoena and to demand the testimony of Mr. Trump and Mike Pence, among others, and to sanction any disobedience to those subpoenas by imprisonment or otherwise without going to court. And yet it's Mr. Pence especially who has the smoking gun. We know there are at least a half a dozen or more incidents where it's been said that the two men were speaking together without anyone else in the room about not counting the state certified electoral votes on January 6th. Why would you not call the man with a smoking gun? That would be like the Watergate committee not subpoenaing the Nixon tapes after Alex Butterfield revealed them. The Nixon tapes brought him down. Remember the tape that showed that he was urging H.R. Haldeman to obstruct justice, and that led to his resignation, Mr. Nixon. So there's one problem is, why have you not subpoenaed Mr. Pence? There isn't any privilege there. No vice president in history has ever successfully claimed a privilege not to testify. He's not even a sitting vice president. And the same thing can be said about President Trump. I worked on the Watergate impeachment of Nixon. There were 4 congressional subpoenas against Nixon for his tapes. He flouted them, and that was an article of impeachment. So when the House is investigating high crimes and misdemeanors, there isn't any presidential privilege, former presidential privilege or otherwise. And this is a dereliction. The American people are entitled to know exactly what Trump said when he was informed there's violence unfolding on Capitol Hill. There's yelling and screaming, hang Mike Pence, among other things. We don't want claims of executive privilege. I don't know. Hey, we can't reveal that. And that's another deficiency. Not only are they not calling the prime witnesses about January 6th, Trump and Pence, but they let Cipollone, the White House lawyer, claim privilege to not disclose exactly what Trump said when he alerted Trump, hey, your followers are committing violence up on Capitol Hill. We know previously when he was informed that his followers were bringing arms into the ellipse, he said, don't check them because they're not coming after me. So these particular words are very important. There may be some callers, and I mean, listeners, and you may remember, Ralph, that John Dean was White House counsel who testified on 5 or 6 complete days before the Watergate committee on blow-by-blow conversations he had with President Richard Nixon. And you remember the words of Nixon that rang like a thunder on an anvil for weeks were when he said in response to raising money to pay off the Watergate burglars, oh, we could do it, but it would be wrong. And those words, well, it would be wrong, looked like, a cover-up, if you will, after he was acknowledging, yeah, that's exactly what they were thinking about, paying the $25,000 as bribes. So where's this idea that they let Pat Cipollone get away with not responding and explaining, well, what in fact did Mr. Trump say? That's very important. There was a case concerning the Clinton.
And there's no, just to interrupt you, there's no executive privilege that can be invoked against a congressional subpoena. You want to elaborate that?
Well, no, there isn't. I say when they tried to claim that in Nixon's case, they impeached him because he flouted the subpoenas and there was no defense. The impeachment power is plenary. And you can imagine why there's no privilege. After all, if the smoking gun is in the White House, how can you give the White House the privilege to cover it up? That makes no sense whatsoever. Are you going to say that a criminal suspect can decide, well, I'm not going to surrender the murder weapon? No, you can subpoena the murder weapon here. Now, of course, there is the privilege, Ralph, of self-incrimination. It's not executive privilege. There's a Fifth Amendment privilege against self-incrimination, and no matter what the context, whether it's in a civil or other proceeding. But Trump has never claimed the Fifth Amendment privilege. And that would obviously, you can draw a negative inference about that invocation in a civil context. And an impeachment proceeding is civil. It's not criminal, which is why after you're impeached, you could still be subject to criminal prosecution. But to say Trump has never insinuated he would invoke the Fifth Amendment privilege against self-incrimination. But there's certainly no executive privilege with regard to current attorney-client privilege. It was established in the Bruce Lindsay case in Clinton that the client of a government attorney, especially the White House, and it was my client when I was in the Justice Department, is the United States Constitution. It is not any individual. We don't do dare, fear, or salute the occupant of the White House. No, that is not your client. When I took an oath to be a government attorney, my oath was to the Constitution itself, period. And anything that subverts the Constitution is a danger, and you have a duty to disclose what that is. So
just to summarize, you're criticizing the January 6th committee for not subpoenaing Trump and Pence, which is really inexplicable to people who know anything about congressional investigations. Eventually, you got to get to the top of the heap. The second is that Congress is not, and the committee is not informing the public that they don't have to go to court and endless appeals and delays to enforce their contempt power if Trump and Pence defy the subpoena. They have inherent, listen to this, please, they have inherent congressional contempt power under the Constitution to enforce their own subpoenas without going to court. In fact, in the 1930s, they did that against an individual and put that person, arrested him, and put him in a little jail in the Congress. Third, you're saying all these attempts by witnesses requested for certain testimony cannot invoke any kind of executive privilege. That's not going to be upheld, and the judicial precedents are in favor of that position. Now we come to the most astonishing of all, that the January 6th committee may complete its hearings and report without urging the invocation of Section 3 of the 14th Amendment, which would disqualify Trump from ever running again for public office. Can you explain that?
Yes, the Section 3 of the 14th Amendment, which, by the way, the U.S. Supreme Court held as a self-executing amendment, like the 15th Amendment. You don't need, or the 13th Amendment. That is, you don't need implementing legislation. It's self-executing. It provides that any person who has taken an oath to uphold and defend the Constitution, who after having taken that oath engages in insurrection or rebellion against the United States, is forever disqualified from holding public office, not only the presidency, Congress, any public office again. And this is something that can be removed by a 2/3 vote of Congress to remove that disqualification. And so you would think, especially in light of Liz Cheney, the vice chair's closing statement to the last hearing, where she said, can the American people need to think, can we ever trust former President Trump with holding public office again, giving the gross derelictions on January 6th? But she didn't follow up and said, well, and under Section 3, we're going to find that he is disqualified because he did engage in insurrection against.
And just to clarify, implementing Section 3 by the Congress does not require 2/3 vote. It is
no. It's
only a majority vote.
Simple majority, and the Democrats have simple majorities in the House and the Senate.
Well, it's interesting that neither the January 6th committee nor any other committee House Judiciary, Senate Judiciary has raised this. But it does reflect something long-standing, Bruce, is that the Democrats are very soft and weak. It's like they have 12 arrows to their quiver, and they're using 2. When they moved against Trump on the first impeachment, you laid out, and all this was put in the congressional record on December 19th, 2019. 12 impeachable offenses, some of them actual federal crimes, committed openly, brazenly, daily, by Donald Trump. And Nancy Pelosi only picked the Ukraine matter, which it wasn't exactly a kitchen table issue for the American people. So the background of softness on Trump is extraordinary, especially since, what did he say once in the middle of his tenure as president?
Well, I've quoted this one as I've memorized, Ralph. July 23rd, 2019, a day that should live in constitutional infamy. President Trump, I quote, "Then I have Article 2, where I have the right to do anything I want as president. The equivalent of saying the king can do no wrong. The equivalent of saying we're back to pre-1776, where the king was the law and the law was the servant of the king." I mean, truly an astounding statement. And that by itself, in my judgment, is an impeachable offense. It's an attempt to subvert the Constitution. He's exclaiming exactly what his purpose and goal is. Not only the Democrats don't use that quote, Joe Biden never even used it in the 2020 election campaign. You will not find the January 6th committee ever quoting those words in the hearings, which is unbelievable to me. I mean, we all remember, I think, the very famous or infamous exchange between Frost and Nixon. And when Nixon said, "Oh, when the president does it, that means it's not illegal." And everybody was alarmed and shocked. What do you mean if the president does it, it automatically means it's not illegal? The president is under the law, not above it. But here we are years later, and Trump says the same thing as Nixon. People shrug their shoulders and move on. Truly stunning.
And even more extraordinary is that this isn't just history. It continues. Trump and the Republicans are continuing in many states to run roughshod over election laws and standards and purging voters and obstructing voting and criminalizing volunteer precinct workers' behavior and intimidation. It all continues. But I'm sure some of our audience are asking, well, what are some of these crimes that Trump openly and brazenly and daily committed when he was president, including something that often many people don't think is a crime, but is a very serious crime: massive obstruction of justice by Donald Trump in the White House. Why don't you start with that?
Okay. Well, John Bolton, by the way, who I know because I worked with him in the Justice Department at one time, very conservative. I disagree on a whole lot of issues, but he wrote after his tenure as National Security Advisor that obstruction was a way of life at the White House. Trump, all the time, he was interfering with the Mueller investigation. He was interfering with the investigation on Halk Bank, a Turkish bank that evaded sanctions against Iran to do a favor for the Turkish current president Erdogan. His whole role was thinking about how can we fire Robert Mueller to do another Saturday Night Massacre? How can we get the Attorney General to not recuse himself? How can we offer pardons and phone calls to people to say, hey, we're still on the team? Indeed, we saw relics of this, Ralph, in the testimony for the January 6th committee, where we have testimony that, yeah, there are calls received from Trump or his alter egos saying, hey, we really believe in you, and if you stay on the teams, the good things will happen to you. An effort to distort and influence the testimony. And obviously, it seems quite clear that a whole slew of Trump pardons, Roger Stone and for Mike Flynn and others, were there to help his friends. And in fact, in the discussion of impeachable offenses at the time of the framing, framers explicitly stated that a president who wields the pardon power to help and favor his friends would be guilty of an impeachable offense. I mean, and Trump has filled that standard in spades. And
obstruction of justice isn't just politics as usual. Some people say, well, politicians always do that. This is a serious crime. This is a serious violation of federal statutes, which can be prosecuted and result in imprisonment.
Yes, the entire Watergate cover-up trial concerning Haldeman, Ehrlichman, John Mitchell, et cetera, they were obstruction of justice prosecutions, and they all succeeded. President Nixon the articles of impeachment voted against him by the House Judiciary Committee before he resigned alleged what? Obstruction of justice. That was the payoff of the Watergate burglars, try to influence testimony before the grand jury illegally. In fact, it was obstruction of justice that was the final straw that broke the camel's back when the tape showed that Nixon was urging H.R. Haldeman to lie and say he couldn't remember things to the grand jury when he could. So, and that was viewed as sufficient to oust the president from power. This is not a garden variety crime. And with regard to President Clinton himself, when he was under investigation, yeah, it was obstruction when it was alleged that he was lying to the to Whitewater grand jury, to Ken Starr, to the judge in the Paula Jones case. And he ended up losing his license. He got contempt of court for lying about not having sex with that woman, fined $90,000. So it's a very, very serious prohibition. I mean, after all, if obstruction of justice could be committed with impunity, our judicial system would collapse. Anybody could get on the witness stand, lie, cheat, steal.
Yeah, just a footnote. In the Mueller report, which was heavily censored by the Attorney General for Trump, there were all kinds of evidence adduced of obstruction of justice. And to this day, even though the Democrats howled at Trump and demanded the Attorney General release the full Mueller report, uncensored, unredacted, they still have not released the Mueller report, and they're in charge. The Democrats are now in charge. So again, they're very soft, they're very weak. Trump knows that. He knows that when his opponents are weak, that's when he becomes most aggressive. Now, there is a federal law that says presidents, vice presidents, other high officials must never use the power of the federal government against their political opponents in an upcoming election, especially. It's called the Hatch Act. What did Trump do on the Hatch Act?
Well, the Hatch Act, criminalizes a candidate for office from commandeering federal resources, federal personnel to influence the outcome of the campaign. And basically, Mr. Trump turned the White House into a crime scene at the time of the convention and before, when he was making candidate speeches from the White House. His wife was making speeches in the support from the White House. Mike Pompeo was utilizing the U.S. Embassy in Jerusalem to support Trump in his candidacy on U.S. property. It goes on. And that's clearly illegal. The other thing that Trump was doing, and people who have got some of their so-called CARES checks, you may recall sometimes they were direct deposits, some say were checks. Mr. Trump put his name gratuitously on the checks to try to make it seem as though you were receiving money not because of Congress, but because Trump, is responsible for this CARES check, and that's what you should consider voting because he's given you some money in part of his program, something that he had to utilize Treasury Department personnel to get his name on all of these checks. And then he used White House stationery to communicate with direct deposit recipients of CARES money to say, hey, we're alerting you. We've deposited X amount of money in your account. This is one of the great things that the president does. It's all on White House stationery. And it was obviously timed, to influence the outcome of the 2020 election. These are examples of the White House. And indeed, his chief of staff at the time, Trump's, Mark Meadows, said, only inside the Beltway people care about the Hatch Act. Nobody else does. As though, a criminal statute doesn't apply, if it's inside the Beltway and people don't care. Well, listen, it does apply no matter what. Hatch Acts are serious violations. You may recall there are huge problems with the Hatch Act that were raised against then Vice President Al Gore in 2000, saying that he was utilizing his vice presidential offices in the EOB to raise money. And that's obviously a partisan issue. And there are questions of whether President Clinton was using the Lincoln bedroom to host guests who would contribute to his campaign. So it's a serious issue. But I think, Ralph, in part, you're asking why are the Democrats so soft? I think at least one of the motivations is they look that they do basically the same thing, and they don't want to have the criminal justice system turned against them when they're no longer in power, which really is quite disgraceful. that crooks are covering up for crooks is what we have.
Of course, there's an order of magnitude. Nobody's done it so frequently, openly, brazenly, regularly, the way Trump has. For example, presidents shift money around here and there in complex budgets that aren't particularly stipulated by Congress when Congress approves the federal budget. But nobody's done it at the scale that Trump did it, in open defiance of a prohibition by the Congress not to spend billions of dollars building the wall on the southern border. Can you talk about that and how we shoveled it from the Pentagon?
This is something, yes, it's an important statute, Ralph, and listeners or viewers. It's called the Anti-Deficiency Act. And the reason why it was enacted was to protect the congressional power of the purse, to make certain that Congress could oversee the executive, control abuses by the power of the purse. And it says, in layman's language, no, it's a crime for the president to spend money on projects that Congress hasn't appropriated the money for. And so, this is litigation showed that Trump diverted scores of billions of dollars of military construction funds, to build a wall with Mexico to address immigration, which is not a military issue. It's an immigration issue. He diverted $80 billion in Federal Emergency Management Agency funds, to pay unemployment compensation, which he thought would help him with his constituents. $80 billion, And so if the president can go ahead and spend money as he wishes, irrespective of what Congress has appropriated the money for, the power of the purse becomes crippled. James Madison described it as the greatest oversight power there is.
As he said, with Article 2, he can do whatever he wants as president. There's one more outrageous pattern of criminality. He set the all-time record for defying congressional subpoenas. Yeah. Could you talk about that?
Yeah, over 100. And of course, the oversight power is very, very critical. Woodrow Wilson once wrote in Congressional Government that the informing function of Congress is even more important than its statutory function or legislative function. Sunshine is the best disinfectant, as Louis Brandeis said. And so overseeing the executive branch is absolutely critical. And let me just give you one example. I hope it's not a diversion. There was no oversight of the Afghan war that continued for over 2 decades. And as a result, Ralph, the United States spent every day for 20 successive years more than $300 million in the Afghan war, to result in a return of the second edition of the Taliban, more barbaric and brutish than the first edition, right? $2 trillion
over $300 million a day.
A day for 20 successive years, every single day. No oversight, nothing. And no one's accountable. You think that what's the signal that gives to the executive branch? Hey, go to war, do whatever you want. No oversight, we can cover it up. We'll never pay a penalty. We'll just move on. That's why the oversight power is so critical.
Actually, the Inspector General for Afghanistan expenditures, the U.S. Inspector General, documented again and again unbelievable looting, corruption, collusion, payoffs, waste. And he at the end, he was asked, well, what was the result of all your investigation? He said, they never led to any law enforcement. Never led to any law enforcement. It's all on the record. One thing I wanted you to elaborate a bit about is the defiance of subpoenas to find out what, because that's a little vague, defiance of subpoenas. Nixon defied 4 subpoenas, and that was enough to set Congress on the course to impeach and convict him and throw him out of office. Trump has defied well over 120 subpoenas from various congressional committees. What were they subpoenas for example?
Well, I mean, there are a variety of inquiries here. But one example would be to go back for the wall to Mexico. After all, they asked, well, what is the documentation, that this is military construction related? You remember the first time around, Trump said when Congress wouldn't appropriate the money, he shut Congress down. Okay. he wouldn't sign the necessary spending bills to keep the government in operation. Then he turns around immediately and says, okay, now I'm going to spend it on my own. So we need the communications. Where did you get that advice? Where is your authority? Where's the documentation that shows you can spend this money? Another area where he was defying is they're asking for information about his refusal to send arms that Congress had appropriated money for to Ukraine in order to get then President Zelensky, who's still president, to go investigate Hunter Biden and whatever. We want the documentation. What is the need under the Impoundment Act that justified that kind of delay? Who did you talk to? Who did you share this information? Who did you talk to in deciding, hey, you want to talk to Zelensky directly and you're not going to give him the arms, especially with regard to his communications with Rudy Giuliani.
A lot of other subpoenas dealt with really bread and butter issues like subpoenaing information about how the Trumpsters shut down the economic protection regulation of the Consumer Financial Protection Bureau or the Food and Drug Administration looking the other way, or the Department of Interior or Department of Agriculture favoring agribusiness, or the big land owners, exploiters of the public land. It dealt with the whole shutdown of the federal government and turning it over to Wall Street and Houston by the Trumpsters. Corruption. So many of his appointees and high government officers had to flee their office. They had to resign under a shadow of wrongdoing, like the head of the Environmental Protection Agency,
Scott Pruitt,
and the Secretary of Interior. Now we come to the most interesting question to Bruce Fein. Why are the Democrats behaving this way? What are the various motivations when they keep tiptoeing and investigating, but they're not using the evidence in full power to make sure that Trump goes back to his casino business, or goes back, or is prosecuted and convicted of these crimes? What's going on here?
Well, it takes some speculation here, Ralph. But both you and I probably collectively have spent like 100 years or more, around these people. And I come to the reluctant conclusion: the Democrats are soft because they have skeletons in the closet. They know they've done the same or similar things, maybe not on quite the same magnitude. And they worry, well, if we lose the elections to the Republicans in the fall, they're going to turn these precedents and they're coming after us. And we got a lot of skeletons that we want to conceal. So we go soft on them, they'll go soft on us. Now, whether that
but
is
why
actually
isn't this corrupt? Why isn't this corruption a winning agenda for the election? It comes in number one always. People, no matter Republican, Democrat, Libertarian, progressive, whatever, whenever you ask people about ranking things they want done away with, the corruption issue is right at the top. It's true around the world too. Why aren't they making this into a winning political issue? Law and order, clean government, responsive government, preserve taxpayer money, get Wall Street off Washington's back, bring it close to the people, make politicians accountable. Those are winning election arguments. What's going on here?
Yeah. And to reinforce your observation, Ralph, I remember after the Nixon investigations, the Republicans were clobbered at the next election. They were like wiped out in November of 1974 after Nixon resigned. So it was clearly a vote of no confidence in anybody who had defended President Nixon or were implicated in his corruption. And the only thing I think of is that they think, well, that may be true. Maybe it'll go for the good for the Democrats or the public, but for us, no, because we got skeletons in the closet. You remember, I don't want to push it too far, the way in which the Republicans kind of came unglued when they did the impeachment of Bill Clinton, and then Newt Gingrich, with the youthful indiscretions, and then you had 2 or 3 speakers had to all resign because they had done the same thing to Clinton. And so I think that on the Democrats, they say, yeah, we may be popular with the public, but when they see our skeletons, when the Republicans get whenever they do get back in power, it'll be a loss for us. So it's just the club instinct up there is, hey, everybody protects everybody else, which is why we haven't gotten into this, Ralph. The January 6th committee has not sought to compel a single member of Congress who has information relating to what Trump said to them on January 6th to come testify. And I guarantee you, there is no privilege for a member of Congress to refuse to testify. The speech or debate clause protection only applies when the executive or judiciary is at work, not the legislative body. And Congress
and that
has
included
not done
that included Senator Lindsey Graham. They haven't
Yes.
subpoenaed him. He was on part of that, and Speaker, wannabe Speaker Kevin McCarthy, right?
Absolutely. Yeah. Kevin McCarthy said things that were quite critical of Trump. We have him, and then he kind of became mealy-mouthed and trying to retract them later on, trying to fall into Trump's good graces. So yeah, Kevin McCarthy would be a prime witness. And certainly that same could be said with regard to Mitch McConnell, who also was on record saying this is a moral condemnation, a legal condemnation. This is all Trump's handiwork, January 6th. Okay, what made you conclude that? Speaker McConnell, or the Majority Leader McConnell, rather, or then Majority Leader. He's not at present. And so these people, and we know that Trump, in fact, called repeatedly senators and members of the House. Members of the House went up to the White House shortly before January 6th, and we're talking about ways in which you could try to obstruct or prevent Pence from counting the votes on January 6th. Well, those members need to be called. Scott Perry, among others, Matt Gaetz, among others, Jim Jordan, among others. What did you tell the president? There's no privilege here. We need to know what you advised him, and what did the president say in return to establish, a corrupt motive? What's going on here? Was there a conspiracy?
I think there's a fear aspect too. The press always says, hey, prosecuting a former president. I mean, that's never been done before, criminally prosecuting a former president. The Washington Post says, for example, the revelations of a federal grand jury investigating Trump on January 6th, quote, raised the stakes of an already politically fraught probe involving a former president. Well, end quote. What are they talking about? If nobody's above the law, it's even more important to go after the top dogs. And
Absolutely.
they keep saying, "Oh, this will divide the country and this and that." But the more people who supported Trump learn of what he's done to our republic, to our Constitution, to our rule of law, to engender more anxiety, dread, and fear about the coming elections, to intimidate voters, on and on and on, to enrich himself, he's going to start losing some of his own supporters. Maybe not the hardcore, but he can start losing 5, 10, 15% of his supporters. But the Democrats don't seem to get that. There's one more thing before we go to Stephen and David for their quick comment or question. You are quite focused on this attempt by the Republican state legislature in about a dozen states. They're trying to set up the overturn of Democratic wins in the coming elections in their state by empowering their legislature to override the electors who won and establish their own electors. Can you elaborate that in clearer language than I just did?
Yeah, the Constitution provides that presidential electors will be selected as the states provide. It says states legislatures, but there's nothing in the language that suggests that when the Constitution references the states or the Congress, it means Congress alone or the states. It's really talking about the government itself. And I don't want to divert, but I think it's important. For example, Ralph, the First Amendment says Congress shall make no law abridging freedom of speech. But everybody understands Congress is a shorthand for Congress, the executive branch. Any arm of the federal government can't abridge freedom of speech. That's why you read Constitution in a broad language. And so then in the language of the Constitution that prescribes the selection of presidential electors, basically the states decide. And some states have constitutions that place limits on what the state legislatures can do under state constitutions. And sometimes the state legislatures delegate certain electoral functions in presidential campaigns to administrative electoral boards and things like that. This part of the state's choice to have separation of powers, if you will. And state legislatures now, at the exhortation of Trumpists, if you will, John Eastman likes, going to say, no, listen, it has to be the state legislature alone. And that if the state legislature is limited by the state constitution, even when the state legislature chooses to amend the constitution, it can't be done. It has to be the state legislature alone that selects the electors. They can't even delegate it, in some arguments, even to the people, which is a ridiculous counter-constitutional argument for well over 150 years. The last state that had the state legislature select electors as opposed to having it a popular vote was South Carolina in 1850s, which is like 170 years ago. So it's an effort to try to deprive the American people through popular vote, deciding who the president is, and entrust it to inbred state legislatures with all sorts of ulterior motives to defy popular will, in favor of self-enrichment.
Right. Imagine overthrowing the election, the will of the people, by state legislative action right after the election. And so people don't think this is all theoretical. The Supreme Court has announced that it is going to take up a case just on that point next year, in the next session. Is that correct?
Yeah, out of North Carolina. Correct, Ralph. Yes. So we've been talking with Bruce Fein, constitutional law specialist, author, advocate, calls it as he sees them, and has testified over 200 times before Congress over the years. And now it's time for Steve and David to have some input, and then we'll go to the audience.
Yes, I have a quick comment and a question because, we do want to get to these audience questions. We've got a lot of good ones. My first comment is that Bolivia just put their ex-president away for 10 years after it was not an attempted coup, it was actually a successful coup. So Bolivia is kind of showing us the way that it can be done. Now to play a little bit of devil's advocate as far as the January 6th hearings go, it seems to me that the January 6th hearings are for the public to lay out the story so that the public understands the sequence of events. And it's fronted by Republicans and it's Trumpers who are all testifying, and it's trying very hard to seem as non-political as possible, and that it really is up to the DOJ to take up the legal cudgel, which it appears this week they are actually we're finding out that they're doing. So I'm just saying that to maybe cut the January 6th people a little break. What do you think?
Well, it's a wonderful comment, and I don't like to be fault finding, Steve, but hey, I lived every single day in Watergate, and that Senate Watergate committee, same task that January 6th committee had. No, and they had, and I saw them, and you should have seen them too. H.R. Haldeman, John Dean, John Mitchell, John Ehrlichman, all the chief people were there and testified. I also was counsel in the Iran Contra committee, and you know who was there? George Shultz, Cap Weinberger, Robert McFarland, John Poindexter. These are the chief people. The precedents are there. This is not novel, asking the January 6th committee to do things that the predecessors have not done. It's stepping up to the plate. When the smoking gun
excuse me, Bruce, the Watergate committee never subpoenaed Nixon, did they?
No, they had the tapes. No, that didn't. But remember this about Nixon. After he resigned, they were going after him for criminality, which is why pardon came forth with President Ford. This idea that he was scot-free, no. The whole reason why Ford pardoned Nixon was because the Watergate grand jury was investigating the indictment. You remember Nixon himself was named as an unindicted co-conspirator in the Watergate cover-up trial. He was named as a co-conspirator.
No doubt, you're right. There's no doubt the Justice Department prosecutors are ready to prosecute Nixon after he left office and went to California. And because he had an ailment, Gerald Ford pardoned him. So they were going after the full force of the law. David, quickly.
Yeah, let me follow up on Steve's question. During Contragate, Bruce, independent counsel Lawrence Walsh secured 3 convictions against Colonel Oliver North, but the ACLU, I think, of all people, helped Oliver North get those convictions vacated because some witnesses had been given some kind of immunity when they testified before the Iran Contra committee. So when we call the January 6th committee toothless, is that because the January 6th committee is worried about repeating what happened with Oliver North and contaminating the Justice Department's case? Are they worried about inadvertently contaminating Fulton County, Georgia, Fani Willis's investigation? Is that why they're—
No, if you go back, listen, I was involved in that. And the reason why Oliver North's conviction was reversed is because some of Lawrence Walsh's people, despite instructions to the contrary, were listening to immunized testimony of Oliver North. So when you're given immunity, that means the government can't use, your testimony against you. And unfortunately, there are some of, because these were highly televised hearings, some of the lawyers were privy to this immunized testimony, and they used it in framing questions for witnesses. And so the court said, no, you've abused the immunity privilege. You went too far. And that is the reason. Now, they haven't granted immunity to anybody. The January 6th committee hasn't. So there isn't any conceivable danger of a reprise of the Ollie North situation.
Great.
Okay, let's open up to the audience. The audience is a sophisticated, serious audience. Please address your questions to this subject. And if you will, address them to Bruce Fein. It's a very rare opportunity. We have somebody who goes back so many years with so much experience and knowledge to respond to your inquiries. Okay.
Thank you, Ralph. I'm going to do the outro for this segment, throw to Russell, come back, and Hannah will start taking us through those questions. So here we go for the radio show. This is what we do, audience members. You won't hear Russell now. We drop that in later. We've been speaking with Bruce Fein. We will link to his work at ralphnaderradiohour.com. Up next, Bruce and Ralph will answer some questions from our virtual audience. But first, let's check in with our corporate crime reporter, Russell Mokhiber. Thank you, Russell. Welcome back to the Ralph Nader Radio Hour. I'm Steve Scrovan, along with David Feldman and Ralph and Hannah Feldman. Hannah, start taking us through some of these audience questions.
Thank you, Steve. So our first question comes to us from Rachel Branch. Rachel, please unmute and ask your question.
I would like to know what it would take to charge Trump with treason and why that isn't brought up.
The answer comes out of the Constitution itself. Treason is the only crime that is in fact defined specifically in the Constitution because the British had so misused the concept to persecute political enemies. And the crime of treason is defined as levying war against the United States. And despite my criticism and belief that appalling things Mr. Trump did, I don't think it constitutes levying war, and that's why treason is not appropriate here.
Thank you for that question. Next one, Hannah.
Our next question comes to us from Dawn Tuvison. Dawn, please unmute and ask your question.
The January or J6 committee has not mentioned anything about who's funded all of this, or if you know that maybe they are investigating that. When you look at all the wood that built the guillotines and the funding of the transportation on the busing of these people, it just seems that there's some money involved here, and we're not hearing anything about that. Thank you.
Well, I think the question's a wonderful question. It may be a little bit overstated. We do have statements from Liz Cheney, and I think in the public domain, that Mr. Trump himself was raising money from his supporters, misleadingly saying, oh yeah, we're going to win all these court cases. And he raised literally millions of dollars. I don't know what the amount is, from the MAGA people. And there's some very wealthy like Mike Pillow, who obviously is supporting the campaign as well. Now, it hasn't got probably to the granular level that, you know, we would like to have an itemized statement of how much money people gave to so much. But it does seem clear that the money is coming from the Trump supporters. I mean, at least it's not coming from taxpayer money, if that's any solace.
Thank you, Bruce. Our next question comes to us from Mansour Johnson. Mansour, please unmute and ask your question.
Hi, Bruce and Ralph. Bruce, you're an attorney with Free Speech for People. I've been following the actions, and I'm wondering, I heard you say earlier that the Congress could invoke that Section 3 of Amendment 14. Where is your group now regarding that? And is it possible, or will the Congress, is it up to the Congress to try to include all the insurrectionists in this denial of ability to run?
Now, remember that as a predicate for the disqualification, you have to have taken an oath as a public official to defend and support the Constitution. And I think the vast majority of the rioters have never taken that oath as public officials. A handful may have. But listen, we just because you may have many criminals doesn't mean ordinarily there's prosecutorial discretion involved here. And the most important to save us from the destruction of a republic and the Constitution is Mr. Trump, because he's the one who said before, to re-quote, then I have Article 2 where I have the right to do anything I want as president. That's a statement of a tyrant. That's a statement of a king. That's the statement of an emperor. And that's why he's the one who needs to be chastened and disqualified more than anyone else, because he's the greatest danger. Now, because
Bruce, the point the questioner made can be expanded. I think he's right in the sense that there were sitting legislators at the state level and at the federal level who did take that oath, and some were also candidates who might have taken that oath. So it could be broadened out to a few dozen other officials, couldn't it?
Oh, definitely it could. It's a matter of, okay, gathering the evidence and deciding, okay, we need to do due process, give people an opportunity to respond, defend themselves. I'm not suggesting we ought to, de facto pardon them. We're dealing with priorities here, and which should take more priority over something else. Now, we're also dealing in an area of law that it might be called virgin territory. There's not a whole lot of history under Section 3. It was invoked shortly after the Civil War in 1871, but in 1872, Congress by 2/3 vote decided, we got to take everybody who was then disqualified and lift the prohibition on holding office again. They did that by a 2/3 vote, as the Constitution requires. So we do know from the U.S. Supreme Court that Section 3 is self-executing. The matter is, okay, which body is entrusted with deciding, okay, has the individual office holder engaged in insurrection against the United States? And my view, as long as due process is satisfied, that is, you give the accused an opportunity to answer, that institution can be the Congress of the United States. It could be an electoral board where a candidate is trying to get on the ballot to run for president. As long as due process is satisfied, all you got to show is, 1, did you take an oath? 2, did you engage in insurrection? And the January 6th facts speak for themselves with regard to Mr. Trump's involvement.
That's good.
Our next question comes to us from Lynn Harvey. Lynn, please unmute and ask your question.
Yes. Should we be concerned about the possibility of criminal charges being brought by Merrick Garland against Donald Trump and his accomplices, and then having jury trials that fail to convict? Would that be worse than not bringing charges at all? Perish the thought.
Well, I think, I served as government high level as well. Your oath is to uphold and defend the Constitution, right? And not to calculate, what the politics are. The politics of justice are always right, in my view. It sets the precedent. So if we have the standards, there's a belief we can prove guilt beyond a reasonable doubt. The fact that you can have jury nullification, which is always possible, remember the O.J. Simpson case, is not a reason to refrain from moving forward with an indictment. It's true that once a jury acquits, that's the end. The government can't seek double jeopardy, have a new trial, or go on appeal. My own view is that the likelihood of acquittal is very tiny. We can extrapolate from the over 200 guilty pleas and convictions that we have for those who have been prosecuted for implication in the January 6th assault. We got 800 cases. We've got 600 more cases to go. There have not been juries or judges who have been sympathetic towards those who have been involved. And also because, to be candid, even if we're being practical, the venue for the prosecution would be in Washington, D.C. And that means the jury veneer is going to be the Washington, D.C. area. And that is not going to be a jury veneer that's going to be predisposed towards favoring Mr. Trump.
Thank you, Bruce. Next question.
Our next question comes to us from Mary E. Mary, please unmute and ask your question.
She's not unmuting. Mary, can you unmute?
All right, we'll come back to Mary later if we have time. So instead, our next question is from Ian Farrell. Ian, please unmute and ask your question.
Hi, Bruce. The question I have is the fact that subpoenas are not being issued, does that not suggest that the whole process is just performative and maybe not very serious? Thanks.
Well, I think that may be a little overstatement. I mean, some people who are critical witnesses testify anyway. I go back to my historical involvement. John Dean testified without subpoenas. That didn't make him an unimportant witness. But the fact that there are an absence of subpoenas does give a signal of weakness, because it suggests if people are on the borderline, hey, should I cooperate or not? Hey, if they know there's no subpoena forthcoming, then I'm not going to say anything, which I believe is why not a single member of Congress who was at the White House talking about trying to obstruct the counting of electoral votes by the vice president on January 6th has been called and insisted to answer questions by the committee. I don't know whether I'd call it unserious. I think it makes them irresolute, because I go back to my suspicion. They're worried, they got skeletons in the closet, and they're worried about setting a precedent that could come back and nip them.
In fact, the Republicans are threatening that if they take control of the Congress, they're going to do the same thing, which is what you're saying might be deterring the Democrats on the January 6th committee of actually subpoenaing Kevin McCarthy and Lindsey Graham.
Yes. And notice also that Lindsey Graham has been subpoenaed by a Georgia state grand jury. You'd figure that, wait a minute, if a Georgia state grand jury is not reluctant to subpoena Lindsey Graham, and that's certainly lower on the hierarchy of power than the January 6th committee, why isn't the January 6th committee trying to subpoena Lindsey Graham? After all, the investigation in the Georgia grand jury is about criminal activity of Lindsey Graham relating to counting the electoral votes and trying to manipulate the results to make Trump the president, even though he lost the election.
Let it be said that I don't think that Trump or Pence would comply with subpoena. They would defy them. But at least the Democrats can say to the country they gave Trump and Pence an opportunity to make their case or defend themselves. So I think politically it's not a wise move that they didn't or they aren't. As now,
there are legal consequences. I apologize, Ralph, for speaking over you, but there are legal consequences as well. In a civil proceeding, it is permissible to draw an adverse inference from somebody that they are guilty of some kind of wrongdoing if they refuse to respond to a subpoena or even invoke the Fifth Amendment. So the fact that they would flout a subpoena, and remember, if they do that, the Congress can hold them in contempt. And if they wanted to, they could have a marshal go put them in detention until they comply. They may refrain from imposing a sanction. But even if they did not impose a sanction of detention, they could still say, okay, we're going to draw an inference against you because you refused to testify. And you obviously are in possession of very critical evidence. And if it was exculpatory, we assume you'd come forward. And that we can assume it's incriminatory, which is why you're not talking.
Good, thank you. Next question.
Our next question comes to us from Stephen Weisensales. Stephen, please unmute and ask your question.
Yes, my question goes back to something Ralph said, and I think you've picked it up since. You said that Congress really doesn't have to, this January 6th committee doesn't have to go through the court system. They can, basically throw people in jail if they want to, if they're not testifying. Could you clarify that? And then talk about Bannon. I mean, why was Bannon in court?
Yeah, okay. That's a wonderful question. The famous case that stemmed from Teapot Dome, it's called Mcgrain versus Dougherty. Those people want to trace down U.S. Supreme Court decisions, in which the Congress decided that a recalcitrant witness would be immediately detained and imprisoned because defying a subpoena didn't want to reveal the scandal of Teapot Dome. The Supreme Court said, yeah, plenary power. This was a unanimous decision. It wasn't a 5-4 decision. It was a unanimous decision. And that means that in what happened in Mcgrain and Dougherty is there wasn't any court proceeding whatsoever. The Congress itself voted immediate contempt for defying the subpoena. Now, if once you're in detention, then you can seek a writ of habeas corpus, claiming you're being illegally detained, which was done in Mcgrain and Dougherty. And the U.S. Supreme Court said, no, you're not being illegally detained. Congress has this authority. Now, Stephen Bannon, wonderful question. You're exactly right. Why didn't the committee just vote to hold him in contempt? And remember, the contempt is civil contempt, not criminal, because he can get out of the contempt by simply complying with the subpoena. It's not a permanent punishment, if you will. So you can be held in civil contempt as well as being criminally prosecuted. And in my view, they should have just, the important thing of Bannon is getting his testimony. They decided that they would make a referral to the Department of Justice, again, because they didn't want to invoke the civil contempt power and let the department then, take whatever heat would come from a criminal prosecution of Steve Bannon. But even today, even with a criminal conviction, they could still impose a civil sanction on him. And they could do things like, okay, we'll grant you immunity because he's already been convicted. So you can't even claim a Fifth Amendment privilege. And then if he defied that, then they could stick him in jail beyond whatever prison term he might get from the judge until he agrees to comply. Why they are not doing this is truly a mystery to me.
Bruce, these are such good questions. We've run out of time. If someone wants to send you a question, do you have an email that you could give them?
Yes. If you want to ask a question of me, my email address is Bruce, spelled like my first name, at Feinpoints, FEINPOINTS.com. And I'm eager to respond to your questions. That's my public duty as a lawyer and a citizen of the United States, who every day I wake up in my complex right behind the James Madison building and say, wow, I'm sure glad we had people to risk that their lives, fortune, and sacred honor so we could have the freedom we got. And the least we can do to express gratitude is make sure our posterity inherits the same freedoms that we inherited.
So well said. Thank you, Bruce Fein, graduate Harvard Law School, class of 1972. And he didn't let the education at Harvard Law School impede his quest for justice for all. Thank you very much, Bruce.
Thank you. Thank you, Ralph. Delighted to be on the program.